Be seated, please. We have a conglomeration of panels today, and as this proceeds, I think the panel reconstitutes twice after this case. I will tell you that after this case, we'll take a very short recess, only for as long as it takes to reconstitute the panel, probably 2 or 3 minutes. First case, of course, is City of Gainesville versus Ed Crepo as property appraiser for Alachua County. And I know, Mr. Brannock, you represent amicus in this case?
I'm representing the City of Gainesville and the amicus parties. Good afternoon, Your Honors. May it please the Court, I'm Steve Brannock of Holland & Knight, representing Gainesville and the amicus parties. I'd like to, if I may, reserve 7 minutes of my time for rebuttal. This case concerns the taxability of certain city-owned communications property that is used to provide public safety, communications, and internet and telephone services. We think that the trial judge was correct in finding that communications property generally is an essential public service, but was wrong to distinguish between the communications towers, which the trial court determined to be taxable, and the internet and fiber optic system, which the trial judge determined not to be taxable.
Can I ask a preliminary question about the procedural posture? This was decided on a motion for summary judgment.
Right. Yes.
And no party is asking that, is contending that the facts were not adequately developed, or that a material dispute in facts should result in a trial instead of disposition on summary judgment.
That's correct. There's really no dispute about the facts. It's a case of the application of those undisputed facts, of the law to those undisputed facts.
And yet the trial court was proceeding under the prior articulation of the law in this area before the Supreme Court decided the case that went up to them from here.
That's true.
So you think, though, that we've got all the facts we need in the record?
Definitely, because I think the Supreme Court, in its decision, talked about the sorts of factual considerations that should be looked at in determining whether a party that's engaged in telecommunications or communication services is engaged in non-taxable, taxable activity, and those factors are already addressed in the record. So I think the record is adequate for this court to decide the issue as a matter of law. The roadmap for the decision, of course, comes from the Supreme Court's decision in the DOR v. Gainesville case, where the court reiterated that under Article 7, Section 3A, municipal property is exempt if it's essential to the health, if the property is used for activities that are essential to the health, moral, safety, and general welfare of the people within the municipality. I think most importantly for the purposes of our...
So it has to be, that's a new standard, right?
No, that's exactly the same standard that the court has long applied. If you compare the language to the language used in the Saunders case back in 1946 and the Jacksonville case in 1951, precisely the same language. In fact, the court at the end of its decision... It has to be essential to the public health and essential to the public morals and essential to the public welfare. And the court expanded, though, on that test as well in saying that it also is the property is used for municipal or public purpose if it promotes the comfort, safety, and happiness of the citizens of the municipality. The court was very clear at the end of its decision at page 254 to indicate that it was not disagreeing with its dissent on the parameters of the test, nor was it changing the test that had long been applied. So the question was applying that test to the property that's involved here. And in doing so, the court noted that telecommunications are essential public services and are exempt if the city goes into those services for the purposes of providing services that are not otherwise available to the public, to provide competition that would otherwise not exist, to encourage investment in the infrastructure of the city, to encourage the introduction of new services. And the record is absolutely clear in this case that those are precisely the reasons that the city of Gainesville went into this marketplace.
Counsel, is it the city's position that leasing space on the towers to private providers of personal communication services amounts to the provision of telecommunication services as contemplated by the Supreme Court in the Gainesville II decision.
I think that's exactly right, that they are incidental to the core communication services for which the tower was built. I mean, there's no question that the towers were built to provide public safety communication services and intergovernmental services, and I don't think there's any dispute in this case that those services would normally be exempt. The property appraiser and the DOR are arguing that because they go ahead and they also lease part of the tower space to the telecommunications providers, that causes this metamorphosis where the towers go from being 100% exempt to 100% taxable. That's just not the case, because the use by the telecommunications companies is entirely incidental to the primary telecommunications uses. For example, I mean, one of the factors that the Florida Supreme Court said we look at is we want to encourage competition. It's very expensive to build a cell phone network. And the city of Gainesville's got 9 towers that are strategically located around the city. Now, you have 2 choices. A company coming in could build new towers, each of which would be in somebody's backyard, or the city of Gainesville can make its communications infrastructure available to these cell phone providers, which obviously makes it much less expensive for cell phone providers to come into town and to compete. So it encourages competition. It helps maintain the primary purpose of the towers is to be there as part of the communications infrastructure in the city of Gainesville. So I think of the power pole analogy, which I think is a very simple analogy. The city of Gainesville has its own electrical grid system. Cable companies come in and want to establish a cable network. It would make absolutely no sense to have a cable company build an entire new infrastructure of poles to distribute their signal when they could just hang those same wires on the existing poles. And that's exactly what's going on here with the city's communications infrastructure.
Let me ask you this. I don't know that there's any indication that any municipality is in the PCS business or whether it's even legal, but is the analysis in this case the same if the city were providing the PCS service at a profit in addition to the essential fire, police, educational services that the towers are used for?
If the city was jumping into that marketplace solely to make a profit, then that would not be, under the Florida Supreme Court's decision, that would not be a public service. But if the city is going into that marketplace to offer services that otherwise would not be available, or to enhance competition, or to ensure that its citizens have access to the latest technology that otherwise wouldn't be available, then it would, in fact,
so that's similar to your argument on the fiber optic.
Very, very much so.
Okay.
Yeah.
But I'm still not clear about your position as to the effect of the recent Supreme Court decision. Do we have telecommunications specific criteria for whether a municipal or public purpose is being served?
We do, because the original decision happened to come up in the context of telecommunication services. The court gave some very helpful examples looking at Section 36401 of the statutes, and specifically said that basically the same question that you had asked, Judge Conant. It said that if you're just going in to make a profit, that's probably not a public service. But if you're going in to provide services that otherwise wouldn't be available, to enhance competition, then you are providing a public service, and it's exempt. And that's precisely what the evidence showed in this case. It showed that for a city like Gainesville...
Take this competition criterion. Yes. If you're talking about a golf course or a marina or some of the other amenities that have traditionally been viewed as appropriate objects of municipal endeavor, there's no requirement there that you are enhancing competition among golf courses or marinas, for example.
Well, it's certainly not clear as a result of this new decision how the court is going to look at something like a golf course or a marina. The court could well say that if you're operating a golf course and the only reason you're doing it is to make a profit, the court, based on its DOR 2 decision, might well say that going forward that's not a public service. But if you were operating that golf course because otherwise there wouldn't be low-cost golf available to students, the elderly, the less affluent, then the court might, in fact, say that providing recreational facilities to the public at large is, in fact, a public service, so that they might well look behind to look at the intent. The fortunate thing we have in our case is that we've got a very solid record of what the city of Gainesville was attempting to do here.
So the city would agree that this court has a sufficient factual record before it to apply the Supreme Court's decision in Gainesville to the facts of this case.
Right.
What about, is there a distinction between the towers, and I'm not sure if it was 2 or 3, that are now being used exclusively to facilitate telecommunications of private companies?
We don't think so, because number one, the towers were all built for the purposes of the public safety communications. Number two, these towers are still all part of the city's strategic infrastructure for communications, and Mr. Hoffman testified exactly to that fact, that they're all critical. Number three, the 3 towers at issue, there were, in fact, at the time the testimony was taken, plans to utilize that infrastructure to provide those services. And number 4, going back to something I was noting before, the telecommunication services that are on those towers are, in fact, incidental to the communication services that are provided by the tower.
But, counsel, given the fact that private providers held leasehold interest in the towers, didn't the trial court correctly apply the governmental test in determining whether the towers were taxable?
The trial court applied that test, but it turned out to be incorrectly applied that test, as this court recognized in its decision, and as the Supreme Court recognized, that the Supreme Court recognized that the governmental test doesn't apply when the city maintains the ownership and control of the property. Now, this is not a situation, just to be clear, where the city has essentially handed the tower over to private enterprise and said, here, we're leasing the entire tower to you. Now, you do what you want with the tower to make a profit or not, just like the city of Sebring turned over its entire raceway to the private providers. Here, the city still maintains full control over the towers, and essentially the private providers have access to a very small part of the tower, that part of the tower upon which they attach their antennas. But I think
Would you agree that leasing space on the towers to private providers was, in fact, a governmental proprietary function?
The lease to these private providers is entirely incidental to, connected with, and in furtherance of the telecommunication services and communication services provided by that tower. They certainly don't turn the tower from being 100% non-taxable to 100% taxable. So the property appraiser and the DOR's argument is because according to them, you build a tower and it's for public safety purposes, it's 100% tax exempt. You allow one cell phone company to attach one antenna to this 150-foot tower, and suddenly that tower goes from being 100% tax exempt to 100% taxable, and that's clearly not what the law says. The law says that if those services are incidental, and we think it's incidental in the sense that they're.
How can private use of the towers be considered incidental to the city's use for municipal or public purposes, where the towers held more private antennas than public antennas?
Well, you recall that Mr. Hoffman in his testimony specifically noted that counting antennas really isn't helpful because the city has an omnidirectional antenna. The city only needs one antenna to do what it needs to do because it goes throughout the entire city. It sends signals in all directions, while the cell phone companies have these directional antennas, and so they might need 4 or 5 antennas to do exactly the same thing as one antenna. So it's not a mathematical calculation. The question is it related to the important public purposes of ensuring adequate public communications in the city of Gainesville? This is not the city of Gainesville opening up a pizza parlor or a casino to help subsidize the tower.
Right, but the constitutional exemption exists for property used exclusively by the municipality.
That's correct.
So at least that portion of the tower on which the private antenna is mounted is not being used exclusively by the city.
But the courts have also said that if that use is incidental to the public use, then it does not render any portion of the the public property taxable, and certainly wouldn't render the entire portion taxable. I think an analogy that I like to use is the cafe in the courthouse. You've got a public building, and in a small corner of the public building, you put a cafe for the convenience of the patrons of the public building. Courts are quite clear that that incidental use, even though someone's making a profit in that cafe, doesn't turn this building from being a public building to a proprietary building. And the courts have never caused even the incidental private use to be taxable. The Gate City Garage case is an excellent example of that. The city builds the parking garage and then leases out a small portion to put a gas station there. Obviously, something that's very much connected with the parking garage. And the court said that, no, that gas station didn't render the parking garage to be taxable because it was perfectly incidental to and connected with and in furtherance of the public purpose. I see that I'm intruding into my rebuttal time, and I'd like to leave some time if I may so.
Help us with that analogy. We have City Hall, we have some space devoted to vending machines. Does that make the City Hall taxable?
No.
Why not?
Well, you have to put in perspective, and I disagree with his interpretation of facts, but in the fact of the City Hall, you could, in fact, because of the nature of the City Hall, you could carve out a leased space. Now, if it wasn't a charitable, because I know a lot of the city halls had when they did for the blind and things like that, but if you carved out a space for a profit, a portion of a building, and the property appraisers do that, and you carve that out, enter a leasehold, then that comes under 196, 199, 2 as a leasehold interest. Now, that piece then can be taxable, but it doesn't impact upon the building that's used for the municipal use. We don't have that here. Now we have other property, and they didn't mention it, which is the Deer Haven, nothing. I don't think the towers either, I disagree, have anything to do with telecommunications in response to the questions. What they were, and understand, these towers were built by the city.
Well, I mean, this sounds like a factual dispute that we were told by the other side did not exist.
It's an interpretation of the facts. The facts reveal the towers, there were 9 towers. The 9 towers were built for a microwave system to utilize for the emergency services of the city of Gainesville. And to connect the city of Gainesville with the fire department, the county essential services. Now, what happened was the FCC came and said, cities, you can't have microwave frequencies any longer. We're going to sell them to the carriers, to the providers, as Mr. Hoffman described them, in the industry. So the towers at that point became an asset the city had and had no viable use for. The trunk radio system they're talking about came along later, and the testimony of Mr. Hoffman was, that's an antenna like you have on your boat. You know, it's a one-stick antenna. You can hang them anywhere. These towers would never have been built, according to him, for that type of antenna. The incidental use is hanging that antenna, which they hang not only on these towers, they hang them on buildings, everything else all over town. The testimony, there's no dispute other than that fact. The same with the fiber optic. Now, I'm going to not go into the statute because I wanted to reserve, after 10 minutes, or if I could be notified, to reserve the balance
Let
for
me
Mr.
ask you about
Bykowski, but yes.
Stop the clock for just a second. You do have co-counsel here from the Department of Revenue.
And, yes.
And you also have Sir Rebuttal available if you'd like it. Tell us how you'd like to divide your time.
Well, why don't I divide it up? At 10 minutes, if you could notify me, and then I'll wind up with the questions we have. Mr. Bykowski is going to look at the fiber optics from the standpoint of the statutory reference. And after that, I don't think there's Sir Rebuttal, because I think it'll all be covered in this.
Okay, well, that's fine. You don't have to do that, even though you have a cross appeal. But at 10 minutes remaining, the sum up light will come on, which is the only way we have to do it. It will turn yellow, which is the first light that you'll have there.
And I'll try to wind up. Now, but I wanted not to be confused. Mr. Crapo, the property appraiser. By the way, I'm John Dent. May it please the court and all of that. The property appraiser, Mr. Crapo, put all this property on the tax roll irrespective of any statute. He made a determination when the use changed of all this property, it changed to a non-governmental use. Now, granted, we were using, when I advised him, obviously, we were using the standard of the governmental, proprietary, governmental. The facts all are still the same. They're not viewed. All the facts were developed. All of this property, and under the decision in the Gainesville case, the court stated However, under the applicable law to this case, municipalities may enter the market regardless of whether their participation furthers any of these goals. The critical part. In other words, a municipality using infrastructure advantages gained from its pre-existing utility operations may enter the market, and when they do that, that is not an exempt purpose. That's what the court said. Now, they had towers. What happened was they didn't know what to do with the towers. They hired Ed Hoffman, who came in and did a business plan that's in the record. In that business plan, he had been approached by some of the carriers, Bell South, AT&T, Bell Atlantic, all of the major carriers. They said, well, you can't use the towers for your microwave antenna, but we can. Lease them to us. So he proposed a plan to go to the city. In fact, it got to the point that some of the towers did not meet the needs of those carriers, so the city rebuilt the towers for that purpose.
What if there had never been, and was not now, any kind of communications operation by the city, but the city decided that as a matter of aesthetics, and I think there may even be health concerns in some quarters about microwave radiation, that they wanted to build a discrete number of towers in a way that would minimize the impact on the life of the community and rent to whoever wanted to compete. Would there be any problem with that, and would there be any question about the public purpose that would serve?
Well, for the other part of the reasoning by the court, remember, it's not whether they're essential services, it's whether they're essential services for the moral safety and welfare of the citizens of Gainesville. These towers are for the welfare of Bell South, Alltel, Bell Atlantic, AT&T for their long distance and their microwave transmission. And remember, they use these towers to transmit the wireless and the other communications. They have a box on the ground which is theirs and taxable, which goes into then the backbone system of either the CLEC, the local exchange carrier, which is, I think, Bell South in this case. So all of this is integrated into the public sector communication system. The city just happened to have, and these are not the only towers in Gainesville that do this. Those providers already had some towers they used. They wanted to expand their service, and they're using these towers to hang their microwave antenna on. So the city said, well, let's divert them to that use.
Do you feel like you are addressing my question?
Well, you're asking me, yes, I think in the sense if the city didn't have these towers, and then the carriers came along and said, we need the towers, city, would you build them for us? Now, in answer, you put in there sort of an environmental issue on it, and I don't know that these towers themselves, this way or any other way, address that. Microwaves are microwaves, whether on the city-owned towers or on towers owned by the private.
The aesthetics. You know, we don't...
These are not built in such a way, and there's no development of facts that somehow they aesthetically are different than the towers owned by the private sector.
I mean,
they're built
just the question about the location.
The location was strategic for the line of sight communications. The microwave uses line of sight, so you have to have a tower that can point to different towers. So they're located strategically to accomplish that. Now, the city's argument that they've made, which we don't accept, is, well, if we didn't have these, then the carriers would have to go out and build 9 more. Well, the carriers already own a whole slew of them all over the city and the county. As opposed to the city had them, they could rent them, as opposed to the city tearing them down and the private sector go building these 9. That's not an issue that they're strategically located in any way that protects the public. They were strategically located for the city's prior operation. I don't want to lose, we have the Deer Haven property, which we feel is it's not telecommunication. What
Councilor,
it is,
before you get to the Deer Haven property, do you agree with the city that this court has a sufficient factual record before it, from the trial court, to apply the Supreme Court decision in Gainesville to the facts of this case?
This court certainly has the facts. The trial court didn't have the law, but this court, I don't know of any other. I mean, we developed the facts pretty in depth by going into the history of this. The fiber optic was not built for general telecommunication. The fiber optic was built between the city and Shands for a government communication. Mr. Hoffman came along, designed a business plan that he could integrate all of those things, assets, so that the city could profit from them. And in his own statement, he alludes to the fact that although the citizens of the city are going to benefit very incidentally, it's a good thing for the city because it produces revenues. They make millions of dollars off of this in revenues every year by being in this. So it wasn't developed. The city didn't say there's a need in telecommunication. Let's go off and develop something to meet that need and foster the goals. The
Isn't
competition was there.
This sounds again like a factual dispute, because there is stuff in the record about Gainesville's a tertiary market and we would never get this quality of service if we hadn't gotten out front and so forth.
But what they've argued is the bandwidth that you can achieve from the fiber optic loop that they laid. Now, there's some other fiber optic in the city. That's not the only mode. You have cable that provides signal strength. You have the old copper, but the coaxial cable, the copper, and some fiber owned by the others. The city...
No party has contested before this court that there were material disputed facts before the trial court.
Well, I don't think they're disputing what I'm saying. I'm taking it from the depositions of Mr. Hoffman in the record. We didn't produce a witness that said, oh, no, what Mr. Hoffman said is wrong. His business plan is his business plan, not Mr. Crapo's. The assets are built historically in the business plan. It says when he came online, there was a fiber optic loop that had been constructed and was in the process between Shands Hospital, the University of Florida, and the city for a closed system.
If you're going to tell us about Deer Haven, you're running out of time.
Okay, well, Deer Haven, I think, is pretty simple. It's a tract of land the city purchased. The city got consideration for a upfront payment for what equates to a leasehold to the timber company. All right, the timber company has possession of the property and use of it, and then they in turn have a lease that excludes the general public off of it for a hunting lease. Now, so
and
the
timber company retained the timber rights to the property as well?
The timber company retained those rights. And for that, they got a reduction in the purchase price. I computed around $480,000. That's in the record.
Given that fact, counsel, are you aware of any authority under which ad valorem taxes could have been assessed against the timber company based on its ownership of the timber rights in the Deer Haven property?
Well, yes, but Crapo, no. Under 196, 199, 2B, if there's a leasehold, and this equated to a leasehold, and the lessee pays rent, it's an intangible, and under Tucker versus Capital City Country Club, it's levied by the Department of Revenue. Now, whether they do their job on that, I'm not here to
So there's a state intangible tax available on that leasehold, but there's no, to follow up here, there's no indication that leasehold is separately taxable by local government.
But legally it's not. By definition, the courts, the courts never ruled on that. Actually, the Supreme Court left that in question, but it's never been challenged. The statute says it's intangible. And so that's where we stand today. Now, if this court wants to entertain a constitutional challenge to that provision, I guess we could.
I don't think we have that before us in this case.
So I think the Deer Haven property, and also...
But you agree with regard to Deer Haven that the city's use of the property at this point is solely as a buffer to an existing power plant, or is there a dispute about that?
Well, they gained a monetary benefit in the transaction and spinning off the timber rights.
They gained a monetary benefit in terms of having to pay a lower purchase price.
Which is just like you used to be able to go to your car dealer, rent a Chevrolet, give them $10,000 up front as an upfront payment, and then you had the lease for the time.
But the city acquired a piece of property that apparently the record indicates that they need both as a buffer and potential prior expansion, and the monetary benefit they gain is not some ongoing revenue flow, but a reduction in the purchase price from the previous owner.
It was based upon a present value of a future income stream from the timber
That's what the
harvesting in
payment
future.
price was based upon.
Excuse me?
That's what the payment price.
Yes, the
discount
reduction was based. It's a present value of a future stream of income that they traded off. They could have done the other and said, well, would you just pay us so much a month or a year for the lease? But we took an upfront reduction in value that was calculated.
The mere fact that the timber rights are reserved and the right to honor this hunting club lease is reserved is not the crux of your argument.
No, that's the other part of my argument.
Okay.
I didn't want to waive that. I was trying to get there. The other part is the Orlando Utilities Commission versus Milligan. Now, in that case, it was the city of Orlando, and they had property that was utilized or owned. It's similar to this. It was Orlando Utilities, which was the city of Orlando. They had a tract of land, and they restricted the use of that to the employees of the utility. It wasn't open to the public as a recreational facility. It was restricted. The court said, and that's been cited in the latest CAPFA case, which is subsequent to Gainesville, and still law, in essence, the hunting lease and the timber rights, by excluding the public, it's no longer an essential service they're providing to the public on this property. They've excluded the public. You have to pay and join the hunting club or the timber company that harvests timber. They manage the property. They have they have possession of it with certain rights that are similar under a lease under the agreement, where the city can go, like if you were a landlord, you can have rights to access to the rental property to view whatever, but they don't have control of it. It's placed in the timber company, and it's...
All right, but their interest is the fee interest. That's what you want to tax.
That's what we want to tax. That's what was taxed in the Tucker case versus Capital City Country Club, and any of the lease, if it's equated to a lease. Even if we use the essential test that we referred to the Supreme Court under this and say it's not a tantamount to a lease, it still fails because that is the use of the property. It's incidentally, it acts as a buffer. The city was protected, which the city should. I'm not faulting municipalities for doing this stuff. I think it's wonderful. They make money.
And it's clear under Mikos that you can buy land just to hold for future purposes.
In future years, yes. Unfortunately, I led the field. That was my case years ago. But in that case, the city came up and testified that it was held for future use, or it was existing parks that they were open to the public. The Supreme Court said in that instance. Remember, on the land cases, we have Sun and Lake out of the second DCA, and which was vacant land, and the Bartow decision was rodent.
What about their point that you're complaining about the use of parts of the bundle of rights that they never acquired?
Well, there's always that part. The landlord always retains a part of the bundle of rights in any case. In any leasehold situation, the landlord, the owner of the property, retains the remainder interest, etc. And they can have co-use of the property as they do in this case. We admit that. It is passively serves as a buffer. But the city turned it into a revenue source by doing that. And also they restricted the use of it to a segment that is not the general public. I can't go out there and hunt or do whatever. I have to join the hunt club, which in turn pays $59,000 a year for those rights. That makes it different than looking at these passive properties or properties that are parks, etc., open to the public. I'm using up time that I shouldn't be, and
We'll
thank
let
you.
Mr. Murkowski make his argument.
I see my good colleague and friend has used up a great deal of my time. If I might beg the court's indulgence, if I could have 8 or 9 minutes, because I just want to limit my comments to the fiber optic network and internet equipment and how that fits in with the statute 166.047. I would also like to reserve 2 minutes for rebuttal of my time.
You do want, sir, rebuttal time.
Yes, I would.
Well, the problem is we've got a full docket this afternoon. I'll give you a total of 7 minutes. If you can reset the clock, I know it's complicated. And at 2 minutes, your yellow light will come on.
That's fine, Judge, and I appreciate that. Our agreement was to split the time 50-50, but unfortunately my co-counsel went over.
Counsel, in reference to the Dehaven property before you move to the fiber optic network, your co-counsel referred to the Department of Revenue in reference to my question. So my question again is, are you aware of any authority under which ad valorem taxes could have been assessed against the timber company based on its ownership of the timber rights on the Dehaven property?
If there's a lease, I know that commercial leases are subject to sales tax. As far as ad valorem tax, I don't have an opinion on that. I did not research that for this. But let me get back to what my primary discussion is here.
Let me ask you, just as a preliminary question along those lines, you do agree that we're talking about a constitutional exemption?
Yes, very much so, Judge Benton. And this is
so it would be beyond the legislature's power to alter the exemption by statute.
This is what I believe the statutory framework, within the constitutional framework is that there's a hierarchy of analysis. First, applying Article 7, Section 3A, you determine with the issue of exclusivity. That is the property being used exclusively for municipal or public purposes? In that case, you're eligible for the exemption. Then you apply the test of Gainesville 2, the core ruling about the health, safety, well-being of the community. So, in other words, it's like when you turn 16 or 17, you're eligible for a driver's license, but you can't start driving till you pass the test. That's precisely what needs to be met by the city in this case. Now, here, it's interesting when the business plan of the city of Gainesville said, however, the start of business activities may only marginally benefit the general population of Gainesville. That's from the city's business plan from 1995. But we have to analyze this case in the context of the tax years in question, which for the internet equipment and the fiber optic network are 2003, 2004. We agree that the trial court, in fact, the parties argued this case probably under the wrong standard because we didn't have the benefit of the Gainesville 2 decision. Now we do. The legislature has the ability to define what's a municipal or public purpose, and it did so in this case. It did when it passed Chapter Law 97-197 and provided for Section 166.047. The city of Gainesville went to the Public Service Commission, got a certificate under Chapter 364. They're in the telecom business. And when the Gainesville 2 decision came out last December, finding that that was a proper statutory scheme and that 166.047 was constitutional, it requires, under its express terms, that they pay ad valorem taxes on their telecom.
Where are we? I mean, the Supreme Court said that it's not a question that you can decide facially, that you have to look at the facts surrounding the telecommunications enterprise.
That's correct.
And what facts do you think are lacking here? Because you can see, this, as you must, this basic point that certain telecommunications operations by municipalities serve public purposes, and therefore the property so employed is exempt from ad valorem taxation.
That's correct.
All right, so what is wrong with the way they are doing business?
There's nothing wrong.
From the standpoint of the tax exemption.
There's nothing wrong with that. But I believe the record in this case that shows that there is a highly competitive telecom market in the city of Gainesville, that they, to the extent applying 166.047, that it provides that this section does not apply to the provisions of telecom services for internal operational needs of the municipality or other entity of local government. That's picking up the exemption of Article 7, Section 3A. But the legislature has said if you're going to engage in this business, you must pay ad valorem taxes on the commercial aspects. In other words, there will have to be an allocation by the property appraiser to the extent that some of it's being used by the city for its own internal needs, which is exempt, but the larger portion is competing actively with all the other telecom providers in the city.
All right, well, I understand that position and appreciate how clearly you have articulated it. Isn't that at odds with the position that that Mr. Crapo is taking, that the entire towers, all of every tower, is taxable?
Yes, we do have that difference in opinions on how it's applied, but it depends on how you define the telecom business. We believe that it includes this telecommunications, two-way communications, the fiber optic network that connects all of the towers throughout the city. But that's the way the statute's written, and the statute, which has been approved by the Supreme Court, has to take into the municipal purposes. And I think, as I've read the latter portion, that's what's done. So there has to be an allocation. We're not saying it's an all or nothing as to the telecom, because that isn't what the statute says. However, we do believe, based upon the record, there's enough, and I know all of the members of the panel have asked, is there a sufficient record to rule? I think probably there is, although when I thought about it, it was a close question. It probably would have been better if we had the Gainesville 2 decision and we were able to to analyze it by bringing in more people from the telecom industry to talk about that. But there is the Lackman affidavit, which is in the record, which shows that there's dozens and dozens of PCS providers, and there's a couple dozen internet service providers in Gainesville. So it is a truly competitive market. So that's why.
However, one point was clear from the record, and that is that things have evolved over time.
That's true. And I think perhaps back in 1995, the city was the only player in town. But those years aren't in question. This tax exemption is being viewed in the context of the tax years in the complaint, and I believe that's 2003 and 2004. As I see I'm down to my last couple of minutes, I just want to just briefly touch on problems with the city's arguments and analysis. First, telecom is not the same as a public utility, such as we have with the electric companies. One is a highly regulated monopoly. I can't get my power from Florida Power and Light because I don't like what the city's charging me for electricity here in Tallahassee. There's no comparison between the electric company cases and telecom. I see I'm out of time. If I could have just 30 seconds, Your Honor, to sum up.
You're out of time, and that is all your time, by the way.
Thank you, Judge. I appreciate your concern. Thank you.
We always try to make sure that the advocates know that when that sum up light comes on, you are into your rebuttal time. Like if there's anyone else in the courtroom that doesn't know that, not finding any fault with you at all, but that sum up light does not mean you're in the last few minutes of your initial argument. It means you're into your rebuttal. Mr. Brannock, you have. We will, out of necessity, are going to allow you another 2 minutes for your rebuttal, even though they got a little bit more than that.
Counsel, you didn't have the
in addition to the 5 minutes that you have.
You didn't have the opportunity to address the Deerhaven property. Would you agree that the Deerhaven property was being used for private purposes on January 1 of 2003 and 2004? Again, did you understand my question?
Right. The Deerhaven property owned by the city was being entirely used for a public purpose. That portion that was being taxed was portions of the property that were never purchased by the city nor owned by the city. I like to use the analogy of the duplex because it's just easier for me. It's as if the city owned one half of the duplex and clearly was using one half of the duplex for a public purpose, and that's all they owned. Someone else owned the other half of the duplex and was engaged in a private purpose. The DOR and the PA are arguing that because somebody else is using the other half of the property that the city doesn't own for a private purpose, that makes the city's property taxable. That just can't be the law, and we don't think that it is the law.
Well, assuming that to be the case, then isn't the property taxable under the Mikos case?
Under the Mikos case, property that's being vacant land, either being used for open spaces or reserved for future uses, which is precisely the use of the Deerhaven property, which is as a buffer between the plant and the residential uses and for potential future expansion of the plant. The Mikos case is that is a legitimate public purpose and that the property would not be taxable. So we think that it's clear. And the fact that there are other parts of the property that the city has never owned that are being used for a private purpose does not render the city.
Well, there does seem to be a little bit of a gulf on this issue between the city's position and the taxing authority's position, and that's what I was having some trouble with in asking these questions. You say that because the city never even acquired these uses that are clearly private uses, that that the taxing authorities simply look at what the city owns, and I guess everybody seems to think that's a public purpose, right. Expansion and buffer. They say, however, that, well, the city gained a substantial amount of revenue by reserving the timber and the hunting rights to the previous owner. And I'm having some trouble with the whole thing as well. I guess the question is, why is your position right and theirs wrong?
I think the simple answer is because you can't tax property that the city doesn't own. The property that the city owns is being used for the public purpose. The property that the city has never owned is being used for.
I guess their position is you own all that you need for your purposes at the present time, since you're not expanding. Why should you also get the advantage of a commercial, some sort of a quasi-commercial use by having a price reduction of $480,000?
Or I guess putting it another way, why should the city have to go out and buy more than it needs to serve its citizens? If all you need to serve your citizens is what the city bought here, why would we make the city go out and buy more than it needs in order to preserve the tax exemption? That doesn't make any sense. Number one, you're causing the city to spend the additional money in the first place, and then number two, you're losing the tax exemption. I just don't think that makes logical sense. In terms of the television...
Do you agree if things had happened in a different order, if the city had acquired the entire property, had then encumbered it with the timber lease and the hunting lease, that they could then tax?
I think our case would be tougher, but I still think that the hunting lease and the timber rights would be incidental to the public purpose, and so therefore certainly that portion of the property that the city retained would not be taxable.
And what is your strongest case for that proposition?
The Mikos case. Then turning back to the towers and the internet property, very strongly disagree with Council's characterization that this is all for the welfare of Bell South and the cell phone providers. First, these towers were built and have always been used for public safety communications. The police department, fire and rescue, communicating with the Alachua County Sheriff Department and all that. It's very difficult for me to see that that's not a core concern of the citizens of Gainesville. In addition to that, having an adequate communications infrastructure is also a core interest of the citizens. If you're in a city like Gainesville, a college town that's dependent upon high tech, and you're competing with cities all across the country to get the best and the brightest in town, you need to have the best possible infrastructure. And the record is absolutely clear in this case that the folks like Bell South and the other major providers go to Miami first. And then they go to cities like Jacksonville first. And then taking up the rear are the smaller towns like Gainesville and I suspect Tallahassee, where you never get the cutting edge services because they're always being built out somewhere else first. But a city like Gainesville, and I would submit a city like Tallahassee, can't survive by waiting until the big companies come around to a city like Gainesville. That's why the city of Gainesville stepped in. The record is absolutely clear that if you look at the purpose, the business plan and the original base plan, they stepped in because at that time there wasn't a single company that was offering broadband internet services in Gainesville.
What about their point that times have changed?
But the record is also clear that even as time changed, I mean, we all know, we all experience this, how the communication systems keeps evolving. Mr. Hoffman testified that even today, the city continues to offer services that are not provided by the other companies because it is focusing on the interests of its citizens and focusing on making sure that its citizens have access to cutting-edge technology that will always be lagging behind 2 or 3 years if you wait for the private companies. And that's precisely what the Supreme Court in the DOR decision said, that if that's what you're doing, if you're making sure that you're providing services that would otherwise not be available.
But three of these towers are what you might call surplus property. The city's not making any use.
They're still part of the infrastructure. The city has plans for future uses for that property, and the uses to which they're putting the property, the enhancement of the telecommunication services are still part of this core interest that I'm talking about. Beyond that,
Okay, so as to the 3 towers, you're also relying on Mikos.
Mikos and other cases that have stated that if a city has surplus property, and this arises most commonly in the electrical context, a city has generation capacity, and it generates excess generation capacity. The courts have always said that you don't turn this public benefit into a proprietary use just by selling the excess, selling the surplus, as you put it, Your Honor, to private providers. That's precisely what's happening here. That surplus doesn't turn this into a proprietary use. I see my time has ended. Thank you very much.
I want to thank you all for excellent advocacy on a complex question. This panel will stand in